January 22nd, 1973. Washington, D.C. dawns under a gray winter sky. Inside the United States Supreme Court building, 9 justices are about to deliver a decision that will resonate for decades. The courtroom is absolutely silent. Chief Justice Warren Burger holds a 113-page document. The words written on that paper will change the lives of millions of women across the country and divide the nation in ways no one anticipated. But this story doesn't begin here. It begins 4 years earlier, in a very different place, with a woman who never wanted to be the center of this battle. Dallas, Texas. Summer of 1969. The heat is stifling. Air conditioning a luxury few can afford in the city's poor neighborhoods. In a small rented room, a 21-year-old named Norma McCorvey stares into the mirror. Her reflection returns the gaze of someone who has lived too much in too little time. Norma grew up in poverty, suffered abuse, and spent time in juvenile detention. At 16, she had her first child, who was given up for adoption. At 18, she had her second daughter, who was placed in the custody of her mother. Now, at 21, she is pregnant again. And this time, Norma doesn't want to go through with the pregnancy. Norma desperately searches for a solution. In Texas, as in most American states in 1969, abortion is illegal except in cases where the mother's life is in danger. Women seeking to end their pregnancies face limited and dangerous options. Travel to another country, find a doctor willing to break the law, or resort to clandestine procedures that often end in hemorrhage, infection, or death. Norma hears rumors about illegal clinics, but she doesn't have the money to pay for them. She considers traveling to California, where the laws are more permissive, but she can't afford the trip either. She feels trapped without options, without a future. A friend suggests something that will change her life. Contact 2 young lawyers who are working on a case like hers. Sarah Weddington is 26. Linda Coffey is 28. Both graduated from the University of Texas at Austin School of Law, where they were part of a small minority of women in a male-dominated world. Both know firsthand the barriers women face in American society in the late 1960s. Sarah herself traveled to Mexico to undergo an illegal abortion as a student, an experience that marked her deeply. Now, she and Linda are convinced that the laws criminalizing abortion are unconstitutional. They violate the right to privacy. They argue they violate individual liberty. They need a perfect case to take to court. And when Norma McCorvey enters their lives, they know they found it. The meeting takes place in a Dallas pizzeria. Norma is nervous, fiddling with a napkin as Sarah and Linda explain their plan. They want to sue the state of Texas. They want to take the case all the way to the Supreme Court if necessary. They explain that they won't be able to get her an abortion in time, that the legal process will take years. But they tell her she can help other women, that she can be part of something bigger. Norma agrees, but on one condition. She wants to remain anonymous. She doesn't want her real name to appear in court documents. The lawyers agree. They choose a pseudonym to protect their identity, Jane Roe. The defendant's last name will be that of the Dallas County District Attorney, Henry Wade. The case will be called Roe v. Wade. Henry Wade is a towering figure in Texas. The Dallas County District Attorney since 1951, Wade has prosecuted thousands of cases during his career. He is known for his toughness, his commitment to law enforcement, and his defense of traditional laws. For Wade, the Texas law prohibiting abortion is clear and must be defended. This isn't about personal opinions, he argues, but about enforcing current legislation. Wade has nothing personal against Norma McCorvey or the attorneys who represent her. He's simply doing his job. But by agreeing to defend Texas law, Wade will become the symbol of a battle that will transcend his person and his office. March 1970. Sarah Weddington and Linda Coffey formally filed their lawsuit in the federal district court for the Northern District of Texas. The document is straightforward. They argue that Texas laws criminalizing abortion violate women's constitutional rights, specifically the right to privacy guaranteed by the 14th Amendment. The lawsuit isn't just on behalf of Norma McCorvey. It's a class action representing all pregnant women in a similar situation. The strategy is bold. If they win, they will help not only Norma, but millions of women across Texas and, potentially, across the country. To understand the magnitude of this case, one must understand America in the late 1960s. The country was undergoing a transformation. The civil rights movement had challenged centuries of racial segregation. The Vietnam War was dividing the nation. Young people were questioning authority, traditional norms, and power structures. And the feminist movement was emerging with force. Women were demanding equality in the workplace, at home, and in politics. They were demanding control over their own bodies. Betty Friedan published The Feminine Mystique in 1963, challenging the idea that women could only find fulfillment as wives and mothers. Gloria Steinem was raising her voice as a champion of women's rights. The women's liberation movement was gaining ground. And in this context, the issue of abortion became a symbol of a larger struggle. Who had the right to decide about a woman's body? May 1970. The case comes before a 3-judge panel of the Federal District Court. Sarah Weddington, only 25 years old and a recent graduate, appears before them to argue the case. It is her first time appearing in federal court. Nerves overwhelm her, but her conviction is unshakable. She argues that the right to privacy, established in previous Supreme Court cases, should extend to protect a woman's decision to terminate a pregnancy. On the other side, lawyers for the state of Texas argue that the state has a legitimate interest in protecting the potential life of the fetus. The hearing lasts barely an hour. The judges retire to deliberate. Norma McCorvey is not present. By then, she has already given birth and placed her 3rd daughter for adoption. June 1970. The 3-judge panel issues its decision, 2-1 in favor of Jane Roe. The judges declare the Texas law unconstitutional because it violates the right to privacy. It's an important victory. But there's a problem. The court doesn't issue an injunction preventing the state of Texas from continuing to enforce the law. This means that even though the law has been declared unconstitutional, women in Texas still can't legally access abortions. Sarah and Linda know they need to go further. They need to take the case to the U.S. Supreme Court. And surprisingly, Henry Wade is also appealing. Both sides want a definitive answer from the highest court in the land. The Supreme Court agrees to hear the case. This is monumental news. Of the thousands of cases that seek review each year, the court only accepts about 100. The fact that Roe v. Wade was selected means that all 9 justices recognize the national importance of this issue. Sarah Weddington begins preparing for the most important moment of her career. She studies previous cases, rehearses her arguments, and seeks the advice of more experienced lawyers. On the other side, Texas lawyers are also preparing. The legal battle is about to reach its climax. But what neither side anticipates is that this decision will not only affect the law, but will transform American politics, culture, and society in ways no one can predict. December 1971. Sarah Weddington climbs the marble stairs of the Supreme Court building. The building is imposing, with its Corinthian columns and its motto engraved on facade, "Equal justice under law." Inside that room, 9 of the most powerful legal minds in the country are waiting to hear her arguments. Sarah carries a briefcase with her notes, but she knows the most important thing is in her mind and her heart. She has 30 minutes to convince the court, 30 minutes to change history. As she walks through the doors and heads toward the podium, one question echoes in her mind. Will it be enough? The main chamber of the Supreme Court of the United States is a space of solemnity and power. The walls are paneled in marble. The ceiling is high and ornate. Behind the bench, 9 black leather chairs await the justices. In front of them, a solitary podium where the lawyers present their arguments. There is no jury, no witnesses. Only legal arguments, precedents, and the Constitution. December 13th, 1971. Sarah Weddington stands behind the podium. In front of her, the 9 justices watch intently. Among them is Warren Burger, the Chief Justice, appointed by President Richard Nixon. There is Harry Blackmun, a Minnesota judge known for his meticulousness. There is William O. Douglas, one of the most liberal justices in the court's history. And there is William Rehnquist, one of the most conservative. Sarah takes a deep breath and begins to speak. Sarah Weddington presents her case with clarity and conviction. She argues that the right to privacy, recognized by the Supreme Court in previous cases, such as Griswold versus Connecticut, should be extended to include a woman's decision to terminate a pregnancy. She cites the Griswold case, where the court declared a law prohibiting the use of contraceptives unconstitutional, based on the right to privacy in reproductive decisions. She argues that laws criminalizing abortion are vague, discriminatory, and harmful, that they force women to seek dangerous and illegal procedures, that they violate their autonomy and dignity. The judges constantly interrupt her with questions. At what point does life begin? Does the state have a legitimate interest in protecting the fetus? What happens in the third trimester of pregnancy? Sarah answers carefully, knowing that her every word will be analyzed and dissected. On the other side, lawyers for the state of Texas present a completely opposite argument. They maintain that life begins at conception and that the state has a duty to protect that life. They argue that the Constitution does not explicitly mention abortion and that, therefore, the decision should be left to the individual states. They cite the legal and medical tradition that has considered abortion a crime for centuries. They argue that allowing abortion would open the door to what they consider a moral collapse. The justices also ask them difficult questions. What if the pregnancy puts the mother's life at risk? What happens in cases of rape or incest? Does the state have the right to force a woman to carry an unwanted pregnancy? The tension in the courtroom is palpable. Two worldviews are colliding, and only one can prevail. But the story doesn't end there. After hearing opening arguments, the court makes an unusual decision. It requests that the case be re-argued. October 1972. Sarah Weddington returns to Washington. This time, she is more experienced and more confident. She has spent months honing her arguments, studying every angle of the case. She has also received support from feminist groups, civil rights organizations, and medical associations. The case has become a national symbol. Outside the Supreme Court building, protesters from both sides gather. Some carry signs that read, "My body, my choice." Others hold images of fetuses and signs that read, "Life begins at conception." The legal battle has become a cultural one. After the arguments, the 9 justices meet privately to deliberate. This process is secret, protected by centuries of judicial tradition. No one outside the court knows exactly what is said in these meetings. But years later, leaked documents and memoirs will reveal some details. Chief Justice Warren Burger assigns Justice Harry Blackmun the task of writing the majority opinion. Blackmun, a meticulous and thoughtful man, spends months researching. He reads histories of abortion, consults medical texts, studies legal precedents. He is aware of the magnitude of what he is doing. He knows his decision will affect millions of people. He knows he will be remembered for this, for better or worse. To understand the complexity of this case, one must understand the history of abortion in the United States. For most of the 19th century, abortion before quickening, the moment a woman feels the first movements of the fetus, usually around 18 to 20 weeks, was legal and relatively common. It wasn't until the second half of the 1800s that states began to pass laws criminalizing abortion. These laws were driven in large part by the American Medical Association, which sought to professionalize medicine and eliminate midwives and other non-physician providers. They were also influenced by concerns about the declining birth rate among middle-class white women. By the early 20th century, abortion was illegal in virtually every state. But that didn't mean they didn't happen. In the 1960s, before Roe versus Wade, it is estimated that between 200,000 and 1.2 million illegal abortions occurred each year in the United States. Illegal abortions exacted a terrible toll. Thousands of women died each year from complications. Thousands more suffered infections, hemorrhages, and permanent damage. Poor women and women of color suffered disproportionately, as they lacked the resources to travel to countries where abortion was legal or to pay for safer procedures. Wealthy women could find doctors willing to perform procedures secretly or could travel abroad. This inequality was stark and painful. In the 1960s, some states began to liberalize their laws. California, Colorado, Hawaii, and New York passed legislation permitting abortion under certain circumstances. But most states maintain strict bans. The patchwork of differing laws created confusion and inequality. A woman in New York could legally access an abortion, but a woman in Texas could not. Harry Blackman works tirelessly on his opinion. He spends weeks in the library of the Mayo Clinic in Minnesota, where he spent much of his career as a lawyer before becoming a judge. He consults with doctors, reads about fetal development, studies medical ethics. Finally, he produces a draft that attempts to balance women's rights with the interests of the state. Blackman divides pregnancy into 3 trimesters. During the first trimester, he argues the decision should be left to the woman and her doctor. The state cannot interfere. During the second trimester, the state can regulate abortion to protect the woman's health. And during the third trimester, when the fetus is viable, capable of surviving outside the womb, the state can prohibit abortion except when the mother's life or health is in danger. This 3-trimester framework will become the heart of the Roe v. Wade decision. As the court deliberates, rumors about the decision begin to circulate. Journalists try to obtain information from sources within the court. Interest groups on both sides are mobilizing. Abortion rights advocates are hopeful. Opponents are worried. Tension is palpable across the country. No one knows for sure what the court will decide, but everyone knows it will be momentous. Right now, the United States is going through multiple crises. The Vietnam War continues. The Watergate scandal is beginning to emerge. The economy is facing inflationary pressures. And in the midst of all this, a decision on abortion is about to add another dimension to the national polarization. Finally, the day arrives. January 22, 1973. The Supreme Court announces its decision in Roe v. Wade. The vote is 7-2 in favor of Roe. Justices Blackmun, Burger, Douglas, Brennan, Stewart, Marshall, and Powell vote with a majority. Justices Rehnquist and White dissent. Chief Justice Burger reads a summary of the decision from the bench. The room is packed with reporters, lawyers, and observers. The words echo in the silence. The court declares that the constitutional right to privacy includes a woman's right to decide whether to terminate her pregnancy. Laws prohibiting abortion are unconstitutional. The decision is immediate and nationwide. In one fell swoop, the court has invalidated anti-abortion laws in 46 states. The reaction is immediate and explosive. Abortion rights advocates celebrate. For them, this is a monumental victory for women's rights, a recognition of their autonomy and dignity. Sarah Weddington, upon hearing the news, feels a mixture of relief and awe. She has achieved the unthinkable. On the other side, abortion opponents are devastated and enraged. For them, this decision is a moral tragedy, an attack on human life. The Catholic Church issues a statement condemning the decision. Evangelical leaders, although initially less involved in this issue, begin to mobilize. Politicians from both parties speak out. Some praise the decision as a step toward individual freedom. Others denounce it as an example of unchecked judicial activism. Somewhere in Texas, Norma McCorvey hears the news on television. Jane Roe has won. Her case has changed the law of the land. But Norma doesn't feel victory. She feels empty. She was never able to get the abortion she sought. Her 3 daughters were given up for adoption. Her name has been used for something bigger than her, but she herself remains in the shadows, anonymous and forgotten. No one knows she is Jane Roe, and for years it will remain that way. But Norma McCorvey's story will take even stranger and more surprising twists in the decades to come. For now, the only thing that is clear is that America has changed forever, and the battle over abortion is far from over. In fact, it's only just beginning. The months following the Roe v. Wade decision brought a seismic shift in the United States. For the first time in generations, women across the country have legal access to abortion. Clinics begin to open. Procedures once performed in secret now occur in safe medical settings. Maternal mortality rates related to illegal abortions drop dramatically. For millions of women, especially poor women and women of color, this represents a transformation in their life choices. They are no longer trapped by unwanted pregnancies. They can continue their education, pursue their careers, and plan their families. But this newfound freedom comes at a cost, a backlash that will reshape American politics for decades. Before Roe v. Wade, opposition to abortion was primarily a Catholic cause. But after the decision, something changed. Evangelical Protestants, who had historically viewed abortion as a private medical matter, began to mobilize. Leaders like Jerry Falwell, pastor at Thomas Road Baptist Church in Virginia, saw in this issue an opportunity to unite religious conservatives. In 1979, Falwell founded the Moral Majority, an organization that sought to influence American politics from a conservative Christian perspective. Abortion became one of its central issues. The term pro-life was adopted to describe those who opposed abortion. It was a carefully chosen term designed to frame the debate in terms of protecting life. On the other side, advocates of legal abortion adopted the term pro-choice, emphasizing autonomy and freedom of choice. 1976. Just 3 years after Roe v. Wade, Congress passes a Hyde Amendment, a measure prohibiting the use of federal Medicaid funds to pay for abortions except in cases of rape, incest, or danger to the mother's life. Representative Henry Hyde, Republican of Illinois, is the author of this amendment. His goal is clear. Although he cannot ban abortion directly, he can make it inaccessible to poor women who rely on Medicaid for their medical care. The amendment has been passed and renewed every year since. Its impact is immediate and disproportionate. Low-income women, especially Black and Latino women, face new barriers to accessing abortion. While women of means can afford the procedure, poor women are left behind. It is a way to restrict Roe without directly overturning it. As the pro-life movement grows, so does its more radical wing. In the 1980s, the first acts of violence against abortion clinics begin. Bombings, arson, death threats. Doctors who perform abortions are harassed at their homes. Their names and addresses are published on websites and in pamphlets. Some are murdered. 1982, a man named Don Anderson planted a bomb in an abortion clinic in Maryland. This is just the beginning. Over the next few decades, there will be hundreds of attacks on clinics. The FBI will eventually classify some of these acts as domestic terrorism. But for the perpetrators, they are acts of moral resistance. They are, they believe, saving lives. This is the horrible paradox of the movement. Some who claim to value life are willing to kill for it. 1980, Ronald Reagan is elected President of the United States. Reagan, a former actor and governor of California, builds a coalition uniting fiscal conservatives with social conservatives. Abortion becomes a cornerstone of this coalition. Reagan promises to appoint judges who will overturn Roe v. Wade. Although he himself signed one of the most liberal abortion laws in the country when he was governor of California in 1967, he now presents himself as a champion of the pro-life movement. During his presidency, Reagan appoints 3 justices to the Supreme Court: Sandra Day O'Connor, Antonin Scalia, and Anthony Kennedy. He also elevates William Rehnquist, one of the 2 dissenters in Roe, to Chief Justice. Abortion opponents are hopeful. They believe they finally have the votes to overturn Roe. During the 1980s and early 1990s, several cases reached the Supreme Court that could have overturned Roe v. Wade. In 1989, Webster v. Reproductive Health Services allowed states to impose further restrictions on abortion. The decision was 5-4. Roe survives but is weakened. In 1992, Planned Parenthood v. Casey reaches the court. Pennsylvania has passed a law requiring women to wait 24 hours before an abortion and requiring minors to obtain parental consent. Many expect the court to use this case to overturn Roe completely. But something unexpected happens. 3 justices appointed by Republican presidents, O'Connor, Kennedy, and Souter, join in a joint opinion reaffirming the fundamental right to abortion established in Roe, although it allows for certain restrictions. It is a stunning victory for abortion rights advocates. 1983. 10 years after the decision, Jane Roe's identity finally becomes public. Norma McCorvey reveals herself as the woman behind the case. She appears on television programs, gives interviews, and becomes a public figure. But Norma is a complicated symbol for the pro-choice movement. She herself has never had an abortion. She is an alcoholic, struggling with addiction and personal problems. She doesn't fit the polished image many activists want to project, but her story is authentic, raw, and human. Norma begins working in abortion clinics, defending the right she herself was never able to exercise. But her journey is far from over. In the years to come, it will take a turn no one anticipated. The 1990s saw an intensification of what are called the American culture wars. Abortion became the defining issue separating Democrats and Republicans. It was no longer possible to be a pro-life Democrat or a pro-choice Republican without facing ostracism within one's own party. Presidential elections were fought over this issue. Candidates were judged on their positions on Roe. Supreme Court justices were confirmed or rejected based on their views on abortion. Polarization was complete. Families were divided. Friendships were severed. At Thanksgiving dinners, abortion was a topic that could not be brought up without provoking a fight. The United States had become two nations with incompatible moral visions living under the same roof. March 10, 1993. Pensacola, Florida. Dr. David Gunn arrives at the Pensacola Women's Medical Services Clinic, where he performs abortions. Outside, protesters hold signs and shout slogans. It's a familiar scene for Dr. Gunn. He has faced protests for years. But today is different. A man named Michael Griffin approaches from behind and fires 3 shots. Dr. Gunn falls to the ground. He will die shortly afterward in the hospital. It is the first murder of a doctor who performs abortions in the United States. Griffin is arrested, tried, and sentenced to life in prison. But the damage is done. The murder sends shock waves through the medical community. Many doctors stop performing abortions out of fear. Access to abortion, although legal, becomes increasingly limited in many parts of the country. As violence and harassment continue, fewer and fewer doctors are willing to perform abortions. Medical schools stop teaching the procedure as part of the standard curriculum. Medical students who express interest in providing abortions face stigma. By the late 1990s, 87% of counties in the United States had no abortion provider at all. Women in rural areas must travel hundreds of miles to access the procedure. They must take time off work, find childcare, and pay for transportation and lodging. For many, these barriers make abortion virtually inaccessible, even when legally permitted. Roe v. Wade remains a law of the land, but its promise is being eroded by 1,000 small cuts. 1995. Something extraordinary happens. Norma McCorvey, the original Jane Roe, announces that she has converted to Christianity and now opposes abortion. The news is earth-shattering. Norma explains that she was baptized by a leader of the pro-life movement named Flip Benham, director of Operation Rescue. She says she no longer believes in the right to abortion, that she regrets her role in the case, and that she now dedicates her life to fighting Roe v. Wade. The pro-life movement celebrates her like a priceless trophy. If Jane Roe herself has repented, they argue, doesn't that prove Roe was wrong all along? The pro-choice movement feels betrayed. But Norma's story is more complex than either side wants to admit. And decades later, she will reveal another shocking twist. The year 2000 arrives with promises of a new beginning. But the battle over abortion shows no signs of abating. That year's presidential election between George W. Bush and Al Gore is marked by the question of who will appoint the next Supreme Court justices. Bush, the Republican candidate, promises to appoint strictly conservative justices. Gore, the Democrat, promises to protect Roe. The election is decided by the Supreme Court itself in one of the most controversial rulings in American history. Bush versus Gore. George W. Bush becomes president, and with him comes a promise of a more conservative court. Abortion rights advocates prepare for new battles. Abortion opponents see new hope. But what no one can predict is how much longer this stalemate will last, or what event will finally break the balance that has kept Roe in place for nearly 30 years. (2008) Barack Obama is elected president, becoming the first African American to hold the office. His election energizes a pro-choice movement, which sees Obama as a committed defender of reproductive rights. But at the same time, Obama's election galvanizes conservatives. The Tea Party emerges as a powerful political force, mobilizing conservative voters in state and local elections. And it is at the state level that the pro-life movement finds a new strategy. If they can't overturn Roe at the federal level, they reason they can empty it of meaning at the state level. They can pass so many restrictions that abortion, although technically legal, becomes practically impossible to obtain. The strategy has a name: TRAP laws, short for Targeted Regulation of Abortion Providers. These laws impose onerous requirements on abortion clinics that don't apply to other comparable medical procedures. They require clinics to have hallways of certain width, doctors to have admitting privileges at nearby hospitals, and procedure rooms to meet unnecessary surgical standards. On the surface, these laws are intended to protect women's health, but their true purpose is clear: to force clinics to close. And it works. Between 2011 and 2016, more than 160 abortion clinics closed across the United States. Entire states are left with 1 or 2 clinics. In Mississippi, there's only 1 clinic left for the entire state. Texas, the state where Roe v. Wade began, becomes the leader of this new assault. In 2013, the Texas legislature passes HB 2, one of the most restrictive anti-abortion laws in the country. The law requires that doctors who perform abortions have admitting privileges at hospitals no more than 30 miles from the clinic, and that all clinics meet ambulatory surgical center standards. These requirements are medically unnecessary. Abortion is one of the safest procedures in medicine, safer than a colonoscopy or giving birth. But that doesn't matter. The goal isn't safety, it's closure. Immediately after the law goes into effect, more than half of the abortion clinics in Texas close their doors. Women in West Texas must now travel 500 miles or more to access an abortion. June 25, 2013. Texas State Senator Wendy Davis steps onto the podium of the Texas Senate. She's wearing pink sneakers. Her plan is to filibuster, speaking continuously for 13 hours to prevent the legislature from voting on HB 2. The filibuster rules in Texas are strict. She cannot sit, she cannot lean on her desk, she cannot take bathroom breaks, and she must stay on topic. For 13 hours, Wendy Davis speaks. She reads testimony from women affected by abortion restrictions. She argues the constitutionality of the law. She explains the medical consequences. Thousands gather at the Texas Capitol in support of her. Millions more watch online. Finally, near midnight, she is forced to halt for a technical violation of the rules. But she manages to delay the vote. However, days later, in a special session, the law passes anyway. Amy Hagstrom Miller is the founder of Whole Woman's Health, a network of abortion clinics that includes facilities in Texas. When HB 2 goes into effect and threatens to close her clinics, Amy decides to fight. Her case, Whole Woman's Health versus Hellerstedt, reaches the Supreme Court in 2016. Oral arguments are intense. Clinic lawyers argue that the law imposes an undue burden on women seeking abortions without providing any real health benefit. Texas lawyers insist they are protecting women's health. The court, now with Stephen Breyer, Ruth Bader Ginsburg, Sonia Sotomayor, and Elena Kagan on the liberal wing, issues a landmark decision. By a vote of 5-3, they strike down the Texas law. It is the most significant decision on abortion in nearly a quarter of a century. Justice Breyer writes that the regulations impose a substantial burden with no medical benefit. It is an important victory for abortion rights. But the pro-life movement doesn't give up. They develop a new tactic, so-called fetal heartbeat laws. These laws prohibit abortion after embryonic cardiac activity is detected, which occurs around 6 weeks into pregnancy, before many women even know they are pregnant. The first of these laws is passed in North Dakota in 2013, but is immediately blocked by the courts. Ohio, Georgia, Mississippi, Kentucky, Louisiana, and other states pass similar versions, and all are blocked. Federal courts find them clearly unconstitutional under Roe and Casey, but state legislators continue to pass them, knowing they will be struck down, hoping that eventually one will reach a more conservative Supreme Court. February 13, 2016. Justice Antonin Scalia dies suddenly while on a hunting trip in Texas. Scalia was one of the most conservative justices on the court and a vocal opponent of Roe v. Wade. His death leaves a vacant seat on the court in the middle of an election year. President Obama nominates Merrick Garland, a moderate justice respected by both parties, to replace Scalia. But Senate Majority Leader Mitch McConnell makes an unprecedented move. He refuses to hold hearings or vote on Garland. McConnell argues that the next president should fill the seat. It is a bold and controversial political maneuver. Garland never receives a vote. When Donald Trump wins the presidency in November 2016, he nominates Neil Gorsuch for the seat. Gorsuch is confirmed in April 2017. Democrats and abortion advocates are furious. They feel the seat was stolen. Donald Trump comes to power promising to appoint judges who will overturn Roe v. Wade. During his campaign, he promised that his nominations would automatically result in the overturning of Roe. Trump nominates 3 justices to the Supreme Court: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. All are considered reliable conservatives on social issues. Kavanaugh faces allegations of sexual assault during his confirmation process, but is narrowly confirmed anyway. Ruth Bader Ginsburg, a fierce defender of abortion rights, dies in September 2020, just weeks before the presidential election. Despite McConnell's argument 4 years earlier that the next president should fill a vacant seat in an election year, he now rushes to confirm Amy Coney Barrett in record time. Barrett is confirmed 8 days before the election. The court now has a 6-3 conservative majority. Abortion opponents finally have the votes they've been waiting for decades. May 2021. Texas passes a law unlike any other in American history. SB 8, or Senate Bill 8, bans abortion after 6 weeks of pregnancy, before most women even know they are pregnant. But what makes this law unique is its enforcement mechanism. Instead of being enforced by state officials, it allows any private citizen to sue anyone who aids or abets an abortion after 6 weeks. Successful plaintiffs can receive at least $10,000 in damages. It's a vigilante mechanism designed to evade normal judicial review. There is no obvious state official to sue to block the law. When clinics try to challenge SB 8 in court, they face procedural hurdles. The law goes into effect on September 1st, 2021. For the first time since Roe v. Wade, abortion after 6 weeks is effectively illegal in a major state. Clinics stop performing abortions after that point for fear of lawsuits. Women are forced to travel out of state or continue unwanted pregnancies. The impact of SB 8 is immediate and devastating. Clinics in Texas see an 80% decrease in the number of abortions performed. Clinics in neighboring states like Oklahoma, New Mexico, and Colorado are overwhelmed by Texas women seeking care. Waiting lists stretch for weeks. Some women can't afford to travel. Others can't take the time off work. Many end up continuing unwanted pregnancies. Stories begin to emerge. A woman who was raped and can't get an abortion. A teenager whose life is at risk. A mother of 3 who can't afford another child. The suffering is real and it's happening now. But for the pro-life movement, SB 8 is a model to follow. Several other states are beginning to consider similar laws. While SB 8 is causing chaos in Texas, another case is moving toward the Supreme Court. Dobbs v. Jackson Women's Health Organization involves a Mississippi law that prohibits abortion after 15 weeks of pregnancy. It's a direct violation of Roe and Casey, which protects the right to abortion until viability, around 24 weeks. But Mississippi is doing something bold. It's not just defending its law. It's explicitly asking the court to overturn Roe v. Wade entirely. The court agrees to hear the case. Oral arguments are scheduled for December 2021. Abortion rights advocates are terrified. They know the makeup of the court has changed dramatically. They know the votes are there to overturn Roe. After nearly 50 years, the constitutional right to abortion hangs in the balance. May 2nd, 2022. In an unprecedented event in Supreme Court history, the website Politico publishes a leaked draft of the majority opinion in the Dobbs case. The document, written by Justice Samuel Alito, explicitly overturns Roe v. Wade and Planned Parenthood v. Casey. Alito's words are unequivocal. Roe was terribly wrong from the start. The draft argues that the Constitution does not protect the right to abortion and that the decision should return to the states. The news explodes like a bomb. Protesters gather in front of the Supreme Court. Some celebrate, others cry. The leak itself is scandalous. Never before has a draft opinion been revealed before the official announcement. An investigation is launched to find the leaker, but so far, no one has been publicly identified. For the next few weeks, America anxiously awaits the official decision. Everyone knows what's coming. The question is no longer if Roe will fall, but when, and what it will mean for the future of America. June 24th, 2022. 49 years after the Supreme Court established the constitutional right to abortion, that same court eliminates it. The decision in Dobbs versus Jackson Women's Health Organization is issued on a summer morning. The vote is 6-3. Justices Samuel Alito, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and Chief Justice John Roberts form the majority. Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan passionately dissent. Alito's majority opinion is nearly identical to the leaked draft. Roe versus Wade and Planned Parenthood versus Casey are overturned. Abortion is no longer a protected constitutional right. The decision reverts to the states. In states with restrictive laws already on the books, abortion instantly becomes illegal. 13 states have trigger laws designed to automatically go into effect if Roe is overturned. Seconds after the announcement, abortion becomes illegal in Kentucky, Louisiana, South Dakota, Arkansas, Missouri, Oklahoma, and other states. Clinics close their doors. Procedures scheduled for that day are canceled. Women in waiting rooms are sent home. Some are in tears. Others are stunned. Doctors are devastated. They have spent their careers providing reproductive care, and now, overnight, they have become potential criminals if they continue. Some states go further. Texas, Oklahoma, and others criminalize abortion from conception, with no exceptions for rape or incest. Doctors who perform abortions face prison sentences. In Texas, the penalty can be life in prison. The three dissenting justices, Breyer, Sotomayor, and Kagan, write a devastating joint dissent. It is a 58-page document filled with anger, pain, and warnings about the future. They argue that the majority has abandoned decades of precedent, that it has made a deeply political decision under the guise of constitutional interpretation, that it has taken away a fundamental right that millions of women have had for nearly half a century. They write, with sorrow for this court, but more so for the many millions of American women who today have lost a fundamental constitutional protection, we dissent. They warn that other rights based on a right to privacy, such as the right to interracial marriage, to contraception, to same-sex marriage, may now be in jeopardy. It is a dissent for the ages, but it does not change the outcome. The reaction is immediate and polarized. Abortion opponents celebrate. For them, this is the moment they've been waiting for decades. They've won their movement's most important legal battle. Pro-life organizations issue declarations of victory. Religious leaders give thanks. Activists who have spent years demonstrating outside clinics feel their work has been worth it. On the other side, abortion rights advocates are devastated. Spontaneous demonstrations erupt in cities across the country. Thousands of people gather outside the Supreme Court, some carrying signs reading "My body, my choice," others with simple messages, "I'm scared." Social media explodes with fury, grief, and calls to action. Celebrities, politicians, and ordinary citizens express their outrage. The United States is more divided than ever. In states where abortion remains legal, clinics are bracing for an avalanche. California, New York, Illinois, Colorado, and other Democrat-majority states promise to become sanctuary states for women seeking abortions. Their legislatures pass laws protecting abortion providers from legal persecution in other states. Clinics expand their hours, hire more staff, and build new facilities. But they can't keep up with demand. Women from Texas travel to New Mexico. Women from Alabama travel to Illinois. Women from Wisconsin travel to Minnesota. Wait times stretch to weeks or months. Some women, especially the poor, can't afford to travel. For them, the repeal of Roe means the end of access to abortion. One option remains: abortion pills, mifepristone and misoprostol. used in combination, can safely terminate a pregnancy up to 10 weeks. These pills were approved by the FDA in 2000. They now account for more than half of all abortions in the United States. After Dobbs, demand for abortion pills skyrockets. Nonprofits begin mailing them to women in restrictive states, defying state laws. Doctors in states where abortion is legal prescribe the pills via telemedicine to women in other states. It's a legal gray area. Anti-abortion states begin passing laws criminalizing receiving abortion pills by mail. But enforcement is complicated. How can a state control what arrives in the mail? How can it monitor prescriptions from doctors in other states? It's a cat-and-mouse game. Stories begin to emerge of the devastating consequences of abortion bans. A woman in Texas suffers a miscarriage, but doctors refuse to perform a DNC procedure, dilation and curettage, because they fear being accused of performing an illegal abortion. She develops sepsis and nearly dies. A 10-year-old girl in Ohio is raped and becomes pregnant. Ohio bans abortion without an exception for rape, so she must travel to Indiana for the procedure. Her story goes national, but Republican lawmakers question its veracity. A woman in Louisiana with an ectopic pregnancy, where the embryo implants outside the uterus and cannot survive, cannot get treatment because the law doesn't make a clear exception. Ectopic pregnancies are fatal if left untreated, but doctors are paralyzed by legal fear. These are not hypothetical scenarios. They are medical realities that occur every day in post-Roe America. Even states that allow exception for rape, incest, or the life of the mother struggle to implement them. What constitutes the life of the mother? Must she be on the verge of death or simply at risk? Who decides? The doctor? A lawyer? A judge? Doctors aren't sure. The law is vague. Many choose not to perform an abortion at all rather than risk prosecution. For rape victims, obtaining an abortion under an exception often requires filing a police report. But many rape victims don't report the crime. They are afraid, traumatized, and distrustful of the justice system. For them, the exception is useless. And for women whose health is at risk but who are not immediately dying, doctors must make an impossible calculation. Wait until she is sick enough to qualify for the exception, or intervene sooner and risk legal consequences. The fall of Roe doesn't end the legal battles. It multiplies them. Now, every state is a battleground. In some states, voters approve constitutional amendments protecting the right to abortion. In Kansas, a conservative state, voters overwhelmingly reject an amendment that would have allowed the legislature to ban abortion. In Kentucky, voters reject a similar measure. In Michigan, voters approve an amendment protecting reproductive rights. These results surprise many. They suggest that even in red states, a majority of Americans support at least some access to abortion. But in other states, Republican legislatures move forward with ever more restrictive bans, and state court battles replace federal court battles. The result is a chaotic patchwork of laws across the country. Some Republicans in Congress are beginning to talk about a national abortion ban. Senator Lindsey Graham of South Carolina is introducing legislation that would ban abortion after 15 weeks nationwide. He argues that just as Roe imposed a national policy of legal abortion, Congress should now impose a national policy of restricted abortion. But this proposal faces two problems. First, it is unclear whether Congress has the constitutional authority to do so. Second, it is politically toxic. Polls show that a majority of Americans do not support a national ban. Many Republicans, especially in competitive states, are avoiding the issue. They have won legally but are losing politically. The 2022 midterm elections show that the reversal of Roe has energized Democratic voters in ways Republicans did not anticipate. Norma McCorvey died in February 2017, 5 years before Roe was overturned. But before she died, she gave a final interview that would be revealed after her death. In a 2020 documentary titled AKA Jane Roe, Norma makes a shocking confession. Her conversion to the pro-life movement in 1995, she says, was fake. She was paid by pro-life leaders to switch sides. I was paid well, she says. I was a good actress. She says she never actually stopped believing in abortion rights. The revelation is devastating for the pro-life movement. Its greatest trophy was a lie. But by then, Norma has already died. She can't elaborate, can't fully explain. Was she telling the truth in the end? Or was she seeking attention one last time? No one knows for sure. What is clear is that Norma McCorvey was used by both sides of this debate. She was a symbol, a pawn, a tool in a war she never asked to fight. And in the end, she died alone, confused and trapped in a battle that bore her false name. 18 months after Dobbs, the United States is living in two parallel realities. In California, New York, Massachusetts, and other blue states, access to abortion is protected and even expanded. In Texas, Alabama, Mississippi, and other red states, abortion is almost completely illegal. Women with resources can travel. Women without resources are trapped. Inequality is profound and growing every day. The data are beginning to show the consequences. More women dying from pregnancy complications in states with bans. More babies born into poverty. More women trapped in abusive relationships because an unwanted pregnancy prevents them from escaping. These are the real costs of the reversal of Roe. But the question no one can answer is, what comes next? Can the pendulum swing back? Can Roe be restored? Or is this the permanent new normal? The answer will determine the future of millions of American women. January 2023. 6 months after the Dobbs decision, the map of the United States is divided into territories that appear to belong to different countries. 14 states have completely banned abortion. 13 others have severe restrictions that make it practically inaccessible. 16 states and the District of Columbia have enacted legal protections for abortion rights. The remaining states exist in a legal gray area, with court battles determining access on a daily basis. For an American woman, her zip code now determines her reproductive rights. A woman in New York has full access to abortion throughout her pregnancy. A woman 300 miles away in Mississippi has no legal access after conception. They are fellow citizens under the same flag, but they live under entirely different legal regimes. A modern underground railroad network is emerging. Volunteers help women travel from restrictive states to states where abortion is legal. They provide transportation, lodging, money for the procedure, and emotional support. These volunteers risk legal consequences. Some states pass laws criminalizing aiding and abetting an abortion, even when it occurs in another state. Texas is attempting to sue websites that provide information on how to obtain out-of-state abortions. Missouri is proposing legislation that would prohibit its residents from traveling out of state for abortions. These laws raise unprecedented constitutional questions about the right to travel between states. But while the cases wind their way through the courts, women need help now, and the volunteers continue to operate discreetly in the shadows. March 2023. A 16-year-old girl in Tennessee discovers she is pregnant. She was raped by a relative. Tennessee prohibits abortion with no exceptions for rape or incest. The young woman is terrified, traumatized, and desperate. Her mother, a woman of limited resources, seeks help. Eventually, they connect with an organization that helps facilitate travel for abortions. They travel by bus for 8 hours to Illinois. The procedure takes less than an hour. They return home the same day. But the story leaks. A local politician in Tennessee attacks the organization that helped the teen, calling them abortion traffickers. He threatens criminal investigations. The story goes national. Proponents point out the cruelty of forcing a 16-year-old rape victim to continue a pregnancy. Opponents argue that the law is the law. The teen and her mother hide from the public eye, re-victimized by a system that was meant to protect them. Doctors in restrictive states face impossible dilemmas daily. A pregnant woman is diagnosed with aggressive cancer. She needs chemotherapy immediately, but the chemotherapy will kill the fetus. Is this an abortion? Is it legal? Hospital lawyers debate for days while the cancer grows. Another woman suffers a premature rupture of membranes at 18 weeks. The fetus won't survive, but it still has a heartbeat. She will develop an infection if she continues the pregnancy. But technically, her life isn't in immediate danger at this point. Should the doctor wait until she's septic to intervene? Another woman has severe preeclampsia, a condition that can cause seizures, stroke, and death. The only treatment is to terminate the pregnancy. But the fetus is viable. Is this an abortion or induced labor? The line is blurred, and the consequences of getting it wrong are devastating. Doctors are beginning to leave states with abortion bans. Medical students are avoiding residencies in these states. Maternal fetal medicine specialists who manage high-risk pregnancies are especially scarce. Why train for years to provide complex care if laws prevent you from doing your job? A hospital in Idaho is closing its maternity unit because it can't recruit obstetricians. A medical university in Mississippi is seeing a 40% drop in applicants to its obstetrics program. The consequences go beyond abortion. These are the doctors who deliver babies, who manage pregnancy complications, who save lives. Their absence creates healthcare deserts that affect all pregnant women, even those who would never consider an abortion. The maternal health crisis in the United States, already worse than any other developed nation, is deepening. Major corporations are entering the fray. Companies like Amazon, Apple, Disney, and J.P. Morgan Chase are announcing they will pay for travel expenses for employees who need to travel out of state for abortions. For these companies, it's an economic calculation as much as a moral one. It's cheaper to pay for travel than maternity leave, childcare, and other costs associated with employees continuing unwanted pregnancies. But the decision is controversial. Republican lawmakers in Texas and Florida are threatening consequences. Some are proposing laws that would deny state contracts to companies that pay for abortions. Pro-life activists are calling for boycotts. Meanwhile, other companies remain silent, unwilling to alienate customers or employees on either side. Abortion has become a corporate human resources issue, a line item on benefit spreadsheets, another battleground in the culture wars. A new concern is emerging: digital surveillance. Period tracking apps collect data on women's menstrual cycles. Google searches reveal who is researching abortions. Phone location records show who visited abortion clinics. In the past, this data was primarily used for advertising. Now, it could be used in criminal prosecutions. In Nebraska, a teenager and her mother are charged after police obtain her Facebook messages about abortion pills. Digital evidence is key to the case. Privacy experts warn women to delete period tracking apps, use private browsers, and encrypt their communications. But most women are not cybersecurity experts. They shouldn't have to be to access medical care. Yet this is the post-Dobbs world, where every digital search, every text message, every bit of location data can become criminal evidence. Some states are going beyond banning abortion. They are beginning to pass personhood or fetal legal personhood laws, which define life as beginning at conception and grant the embryo the same legal rights as a born person. Georgia passes a law allowing pregnant women to claim the fetus as a dependent on their taxes and drive in high-occupancy vehicle lanes. It sounds beneficial, but the implications are terrifying. If a fetus is legally a person, can a woman be charged with homicide for miscarriage, child abuse for drinking alcohol while pregnant, child endangerment for not wearing a seatbelt? These are not hypothetical questions. In several states, women have already been arrested in jail for miscarriages, accused of causing death through drug use or other conduct. Pregnancy is becoming something women can be criminally liable for handling improperly. The world watches the United States with a mixture of bewilderment and horror. For decades, the United States positioned itself as a leader in human rights, including women's rights. Now, it is moving in the opposite direction as the rest of the developed world moves forward. In 2023, France enshrines the right to abortion in its constitution. Mexico decriminalizes abortion domestically. Colombia expands access. Argentina legalizes it. Poland and Hungary remain restrictive outliers in Europe, and now the United States is joining them. American diplomats face uncomfortable questions. How can they promote women's rights abroad when they are being suppressed at home? The hypocrisy is evident. America's global influence on these issues is diminishing. Adversaries are using the Dobbs decision as propaganda, pointing to flaws in American democracy. Abortion dominates the 2024 elections. It is the number one issue in voter polls. Democrats make the protection of reproductive rights the centerpiece of their message. They promise to codify Roe into federal law if they gain control of Congress. Republicans are divided. Some double down on their opposition to abortion, promising even harsher restrictions. Others, especially in competitive states, try to downplay the issue, knowing it is politically toxic. Donald Trump, seeking a return to the presidency, takes credit for appointing the justices who overturned Roe, but also suggests that state bans should have exceptions. His positions shift depending on the audience. The election becomes a referendum on Dobbs. The results will show whether the United States wants to continue down this path or find a way to restore access to abortion. Amid all the political and legal debates, there are voices that are rarely heard. Those of women who truly need abortions. The woman who already has 3 children and can't afford a 4th. The college student whose future will evaporate if she must drop out. The woman whose pregnancy has fatal abnormalities and who wants to avoid months of pain knowing the baby won't survive. The woman in an abusive relationship who knows a baby will tie her to her abuser forever. The woman with health conditions that make pregnancy dangerous. Each has a complex and human story. But in public discourse, they are reduced to statistics, symbols, political tools. Their lived experiences, their pain, their real medical needs are lost in the noise. And while politicians debate and lawyers litigate, these women suffer the very real consequences of the decisions others make about their bodies. June 24th, 2024. 2 years since Roe v. Wade was overturned. Demonstrations occur on both sides. Abortion opponents celebrate their victory and vow to continue fighting until every state bans abortion. Abortion rights advocates gather with renewed resolve, vowing that the fight is not over. The data are beginning to reveal the full impact of these 2 years. Birth rates have risen in states with bans, but so have maternal mortality rates. More women are dying from pregnancy complications in states where doctors fear to intervene. More babies are being born into extreme poverty. The foster care system is overburdened. Social services are overwhelmed. These are the hidden costs of banning abortion. It affects not just the women who seek abortions, but entire families, communities, and the nation's social fabric. And the question remains, can a nation divided so deeply on such a fundamental issue find some kind of common path forward? Or is this war doomed to continue forever? March 2024. A new battle is brewing. Some states are beginning to consider restrictions on certain types of contraceptives, specifically intrauterine devices, IUDs, and the morning-after pill. They argue that these methods do not prevent conception, but rather prevent the implantation of an already conceived embryo, according to the logic of fetal personhood laws. This could be considered an early abortion. Idaho is proposing legislation that would restrict access to these methods. Missouri is considering similar measures. Reproductive health advocates are alarmed. Contraceptives have been legal and widely available since the Supreme Court's decision in Griswold v. Connecticut in 1965. If states can regulate or ban certain contraceptives, what's next? Activists recall the dissent in Dobbs that warned of the slide down a slippery slope. Rights that once seemed secure are now in question. February 2024. The Alabama Supreme Court issues a shocking ruling. Frozen embryos created during in vitro fertilization treatments are extrauterine children under state law. The decision stems from a lawsuit where someone accidentally destroyed frozen embryos at a fertility clinic. The court rules that this constitutes wrongful death. The implications are immediate and devastating. Fertility clinics in Alabama immediately cease operations. If every frozen embryo is legally a child, the clinics face massive legal liability. In vitro fertilization treatments typically create multiple embryos, and not all of them are implanted. What are clinics supposed to do with the remaining embryos? Freeze them indefinitely? Destroy them and face homicide charges? Couples who have been struggling with infertility for years are watching their dreams of having children evaporate. Ironically, a decision meant to protect life is preventing life from being created. The chaos in Alabama spreads. Other fertility clinics in states with strict fetal personhood laws begin to close or refuse new patients. Couples who can afford to travel to states like California or New York for treatment. Those who can't are left without options. The infertility community, which has typically remained on the sidelines of abortion debates, is suddenly drawn into the spotlight. Many of these couples are conservative, pro-life themselves. They never imagined that laws designed to prevent abortions would affect their ability to have children. They begin to organize, lobbying lawmakers. In Alabama, the legislature quickly passes a law protecting fertility clinics from legal liability. But the damage is done. Trust is broken. And the question remains, if a frozen embryo is legally a person, how can in vitro fertilization continue to exist? May 2024. A Republican congressman from Texas proposes federal legislation that would require all healthcare providers to report data on pregnancies and their outcomes to a national database. Officially, the purpose is to monitor maternal health. But critics see a more sinister motive: to create a surveillance system to track abortions. If the government knows when a woman becomes pregnant and then that pregnancy ends, can that information be used to investigate whether an abortion occurred? To prosecute the woman or the medical provider? Civil rights groups and medical organizations fervently oppose it. They call the proposal an Orwellian surveillance state. The bill ultimately fails, but the fact that it was proposed at all reveals the lengths some are willing to go to enforce abortion bans. Despite efforts to restrict them, abortion pills continue to flow. International organizations ship mifepristone and misoprostol from Mexico, Canada, and Europe. Clandestine networks within the United States distribute the pills hand to hand. Groups like Aid Access, led by a Dutch doctor, ship pills directly to American women, defying state and federal laws. The FDA tries to intercept these shipments, but it's like trying to stop the ocean with your hands. The pills are small, easy to hide, and the demand is enormous. Some states pass laws criminalizing possession of abortion pills, but enforcement is nearly impossible. How can police know what pills someone is taking? Will they randomly search homes? The gap between law and reality widens every day. A wing of the pro-life movement is beginning to push for something more radical: fetal abolition. They argue that current pro-life laws don't go far enough because they typically don't punish women who obtain abortions, only the providers. Fetal abolitionists want to treat abortion as homicide, with women facing the same penalties as murderers. Louisiana is considering legislation that would make abortion a capital crime, potentially punishable by the death penalty. The measure ultimately fails but receives significant support. More established pro-life groups distance themselves from the abolitionists, saying that women are victims of abortion, not perpetrators. But abolitionists argue that this is inconsistent. If abortion is truly murder, then it should be treated as such with no exceptions. The debate reveals a fissure within the pro-life movement itself over how far punishment should go. Some Democratic governors are taking defiant stances. The governor of California issues an executive order declaring that his state will not cooperate with other states' abortion investigations. He refuses to extradite doctors accused of providing abortions to out-of-state residents. The governor of New York does the same. They argue that they are protecting constitutional rights under their own state laws. But this creates a direct conflict with other states. Texas issues an arrest warrant for a doctor in California who prescribed abortion pills via telemedicine to a woman in Texas. California refuses to honor the order. It's a standoff between states reminiscent of 19th century conflicts over slavery and states' rights. The constitutional question is profound. Can a state criminalize conduct that occurs in another state where that conduct is legal? The courts will eventually have to sort this out, but for now, chaos reigns. The pro-life movement has long relied on testimony from women who say they regret their abortions. But after Dobbs, different stories begin to emerge. Women who regret not being able to obtain abortions. A woman in Arkansas who was forced to continue a pregnancy after rape speaks about the trauma of raising her rapist child. A woman in Texas who nearly died from an ectopic pregnancy because doctors took too long to intervene shares her story. A woman in Oklahoma who gave birth to a baby with fatal abnormalities and had to watch it suffer for hours before dying describes her pain. These stories are heartbreaking and personal. They challenge a narrative that all women regret abortions and never regret continuing pregnancies. The reality is more complex. Some women regret abortions. Others regret not having them. And politics shouldn't dictate which stories are allowed in public discourse. November 2022. A group of doctors and anti-abortion organizations file a lawsuit against the FDA, seeking to revoke the approval of mifepristone, the pill used in medication abortions. They argue that the FDA failed to follow proper procedures when it approved the drug in 2000, and that it is dangerous. The medical data does not support this. Mifepristone is remarkably safe, with serious complication rates of less than 1%. It is safer than Tylenol, safer than Viagra, safer than giving birth. But the case moves forward. In April 2023, a federal judge in Texas rules in favor of the plaintiffs and suspends the FDA's approval. The decision is shocking. If upheld, mifepristone will become illegal nationwide. Even in states where abortion is legal, other judges issue conflicting rulings, creating legal chaos. The case quickly heads to the Supreme Court. June 2024. The Supreme Court issues its decision in FDA v. Alliance for Hippocratic Medicine. In a stunning ruling, the court rules 9-0 that the plaintiffs lack standing to sue. The justices argue that the physician plaintiffs cannot show they have been personally harmed by the availability of mifepristone. It is a technical, not a substantive, victory. The court does not address whether the FDA acted appropriately in approving the drug. It simply says that these specific plaintiffs have no standing to challenge it. Mifepristone remains legal, but the victory feels fragile. Other plaintiffs with stronger standing could try again, and the court made clear that it is not ready to proactively protect access to abortion. It is only following narrow procedural rules. For abortion rights advocates, this is a relief, but not a celebration. Creative reproductive rights groups are developing a new tactic: mobile abortion clinics. They are medically equipped recreational vehicles that park just across state lines. A woman in Texas can cross into New Mexico, board the mobile clinic, receive an abortion, and return home, all in the same day. The mobile clinics operate in a legal gray area. Technically, they are in territory where abortion is legal, but Texas and other states are trying to find ways to stop them. They sue, alleging the clinics are facilitating violations of Texas law. They pressure state border patrols to question women who cross state lines. It's a disturbing reminder of the era of the fugitive slave laws, when slave states tried to recapture enslaved people who had escaped to free states. History repeats itself in disturbing ways. October 2024. The presidential election is weeks away. Polls show a nation split exactly down the middle. Abortion is a defining issue of the campaign. The Democratic candidate promises to push federal legislation that would codify Roe v. Wade. The Republican candidate promises to veto any national abortion ban, but says the decision should remain with the states. Neither position satisfies everyone. The stakes couldn't be higher. If Democrats win the presidency and control Congress, they could pass a federal law protecting abortion rights. If Republicans win, they could nominate more conservative judges and continue eroding access. 52 years after this battle with Jane Roe began in a Dallas pizzeria, the United States is on the cusp of deciding its direction for the next few decades. The future of reproductive rights, and perhaps American democracy itself, hangs in the balance. January 2025. 52 years have passed since the Supreme Court ruled on Roe v. Wade. 2.5 years since that same court overturned it. The United States has undergone a complete transformation in abortion access twice in the lifetime of a generation. To understand where the country is going, you have to understand where it came from. Before Roe, abortion was a medical issue, debated primarily among doctors. Roe transformed it into a political issue, debated in election campaigns. And Dobbs transformed it again into a battleground where each state writes its own rules. The question no one can answer with certainty is this permanent? Or is it just another chapter in a story still being written? Sarah Weddington, the young lawyer who argued Roe v. Wade before the Supreme Court, died in December 2021, months before Dobbs was decided. She was 76. She did not live to see her greatest achievement dismantled, though she certainly saw the threats accumulating for decades. In her later years, Sarah gave lectures, wrote memoirs, and championed reproductive rights. She always insisted that Roe was not just about abortion, but about autonomy, dignity, and the fundamental right of people to make decisions about their own lives. Linda Coffey, her co-counsel, retired from legal practice and lived a more private life. She rarely spoke publicly about the case. Both women were young and bold when they took on this case. They changed the course of American history. And no matter what one thinks about abortion, that is undeniable. Norma McCorvey's story remains one of the most complex and tragic in this saga. She was used by both sides of the abortion debate. The pro-choice movement turned her into a symbol without actually knowing or supporting her. The pro-life movement paid her to switch sides and then paraded her like a trophy. In the end, she confessed that her conversion was fake, but even that confession is shrouded in ambiguity. Was she telling the truth? Was she seeking attention? Was she bitter about both sides that had used her? Perhaps we will never know. What we do know is that Norma McCorvey was a poor, traumatized, and vulnerable woman who became the face of one of the most polarizing debates in American history. She never got the abortion she sought. She never had the chance to raise any of her 3 daughters. Her life was marked by addiction, abuse, and loneliness. Jane Roe won in the Supreme Court. Norma McCorvey lost in almost every other way. Beyond the legal and political battles are the real human costs. Since Dobbs was decided, researchers have begun to document the consequences. Maternal mortality rates have increased in states with abortion bans. Women are dying from preventable complications because doctors are afraid to intervene. Babies are being born with fatal conditions that were detected on ultrasounds, but mothers were forced to continue the pregnancies. Child victims of rape are giving birth. Women in abusive relationships are trapped by pregnancies they did not choose. These are not hypothetical cases or abstract statistics. They are real human beings with names, families, dreams, and pain. Every abortion ban has a human face behind it, and those faces are suffering in ways that should trouble anyone's conscience, regardless of their beliefs about when life begins. Politically, the reversal of Roe has reshaped the American landscape in ways Republicans did not fully anticipate. In the 2022 midterm elections, Democrats performed much better than expected. Instead of predicted red wave, they retained control of the Senate and narrowly lost the House. Analysts attribute this directly to the backlash against Dobbs. Young voters, especially young women, mobilized in unprecedented numbers. In state after state, abortion referendums have consistently favored abortion access, even in conservative states like Kansas and Kentucky. This suggests that while the pro-life movement won the legal battle, it may be losing the political and cultural battle. A majority of Americans, according to consistent polling, believe abortion should be legal in at least some circumstances. Outright bans are unpopular, even among many conservatives. The Supreme Court itself has become a political issue in unprecedented ways. Before Dobbs, the court enjoyed relatively high levels of public trust. After Dobbs, that trust has plummeted. Polls show that a majority of Americans now view the court as a political rather than a judicial institution. Some Democrats have begun calling for sweeping reforms, expanding the number of justices, imposing term limits, creating stricter ethics codes. Republicans fervently oppose them, arguing that such changes would further politicize the court. But the damage has been done. The Supreme Court is no longer seen as a neutral arbiter above politics. It is seen as just another arena of partisan combat. And that perception, regardless of whether it is fair, erodes the legitimacy of the institution itself. History offers some lessons about how these debates end. Alcohol prohibition was constitutionally mandated in 1920 and repealed in 1933, when it became clear that it was unenforceable and was causing more harm than good. Laws against interracial marriage were upheld by the Supreme Court in 1883 and finally struck down in 1967. Sodomy laws criminalizing same-sex relations were upheld by the Supreme Court in 1986 and struck down in 2003. In each case, what once seemed permanent eventually changed as social attitudes evolved. The question is whether abortion bans will follow a similar pattern. Will they be repealed in a few years when their consequences become unsustainable? Or do they represent a more lasting change in American law? Only time will tell. There's an entire generation of American women now growing up with fewer reproductive rights than their mothers and grandmothers. A teenage girl in Texas today has less bodily autonomy than her grandmother had at her age. This is extraordinarily rare in American history. Typically, rights expand over time, not contract. American history is generally a story of increasing inclusion, of more people gaining more rights. But abortion is now an exception to that narrative. And for young women growing up right now, the message is clear. Your rights are not guaranteed. They can be taken away. You must constantly fight for them. It's a powerful and potentially mobilizing lesson. This generation may become the most politically active in decades, shaped by the experience of watching fundamental rights evaporate. Profound questions remain unanswered. When does life begin? Does a 6-week-old embryo have the same rights as a born baby? What about a 6-day-old embryo? Does the state have the right to force someone to use their body to keep another alive? If so, why can't we force people to donate organs or blood? How do we balance the competing rights of the pregnant woman and the fetus? Where do we draw the line and who decides? These are philosophical, theological, and ethical questions that humanity has debated for millennia. They have no easy answers. Reasonable, well-intentioned people come to entirely different conclusions based on their values, experiences, and religious beliefs. The tragedy is that the United States has turned these deeply personal questions into political battles where the winner imposes their vision on everyone else. Some observers have suggested that a compromise is possible. Perhaps abortion could be legal during the first trimester, when the vast majority of abortions occur anyway, and more restrictive afterward. This would roughly reflect American public opinion, where a majority supports early access but is more ambivalent about late-term abortions. Indeed, this is essentially what Roe v. Wade established. Stronger protection in the first trimester, regulation allowed in the second, and prohibition allowed in the third with exceptions. But both sides of the debate have rejected this kind of compromise. Pro-life activists say that life begins at conception and any abortion is murder. Pro-choice activists say that bodily autonomy is absolute and there should be no government restrictions. The extremes on both sides dominate the debate, making middle ground impossible. And so the war continues. As the United States continues this debate, the world moves forward. Medical technology advances. Abortion pills become more globally accessible. Telemedicine makes it possible for doctors to provide care across borders. Artificial intelligence is beginning to play a role in diagnosing pregnancy complications. Premature babies are surviving to increasingly earlier gestational ages, changing the viability debate. Contraceptive methods are improving, potentially reducing the need for abortions. At the same time, climate change, economic inequality, and political instability are creating new pressures on families and reproductive decisions. The context in which this debate occurs is constantly shifting, and yet fundamental positions remain remarkably static, frozen in stances that were established decades ago. So what is the ultimate legacy of Roe v. Wade? It depends on whom you ask. For abortion rights advocates, Roe represented a fundamental recognition of women's autonomy and dignity. Its reversal is a tragedy that will result in unnecessary suffering and death. For abortion opponents, Roe was a tragically misguided judicial decision that resulted in the deaths of millions of unborn lives. Its reversal is a long overdue moral victory. Both sides view this story through entirely different lenses. Both believe they are on the right side of history. Both are absolutely convinced that their opponents are fundamentally wrong. And therein lies the rub. On an issue where both sides see absolute moral imperatives, compromise becomes nearly impossible. The story of Roe v. Wade is not just about abortion. It is about how a democracy handles profound disagreements about fundamental values. It is about the limits of judicial power. It is about the balance between individual rights and state interest. It is about who decides the most intimate questions of human life. And more than 50 years after it began, these questions remain unanswered. America is still divided. Women are still fighting for autonomy. States are still writing conflicting laws. Courts are still issuing conflicting rulings. And somewhere, real women are facing impossible choices about their bodies, their futures, and their lives. This is a story of Roe versus Wade, a court case that became a culture war that defined a nation. And the story isn't over yet.